For the next speaker of the day, we have Professor José Miguel. We are delighted to welcome you, Professor. He is also a distinguished lawyer and lecturer in the field of dispute resolution with deep expertise in ADR. He holds dual LLM degrees in investment treaty arbitration and international commercial arbitration law from prestigious Swedish universities. His academic work explores the intersection of psychology and law, particularly in the context of arbitration and enforcement mechanisms. Professor Jose currently serves as the head of thesis production unit at University of San Martin of Porres and is the president of Arbitration Council at Lima Region's Chamber of Commerce. We invite you, Professor, to enrich today's session with insights on current scenarios of ADR in Peru. The stage is now yours.
Thank you so much. Thank you so much to everyone. As I'd like to take a couple minutes at the beginning to thank the organizing and production teams behind this impressive event that gathers so many of us and allows us to share our national view on the perspective on ADR. I particularly find it very interesting that we are having this 24-hour event like the week right before Shavuot, which is a holiday in which we study the law for 24 hours in celebration of receiving the Torah from God. So that's a very peculiar coincidence. I'm so glad I get to be a part of this. I also like to thank my fellow speakers for taking the time to illustrate us on their national approach. Um, for what undeniably is a private effort to preserve peace within the confines of our respective jurisdictions. I believe ADR arbitration, of course, but ADR in general is an effort to promote peace and resolution that keeps us further and further away from violence, which, in the context of Latin America, it's an effort, a daily effort where that we're pushing. So as far away as from violence as we can be. So having said that, thank you so much once again for letting me speak today about these issues. Now, I was asked to talk about the existing arbitration legislation in Peru, um, but approaching just the Arbitration Act of 2008 wouldn't do justice to the sui generis system that we have here in Peru. You'll see. The Peruvian Arbitration Act of 2008 follows very closely the 2006 ancestral model law, with some Lima-centric texture. Um, for example, international arbitration that has its seat in Peru needs to go through Lima courts, even if the seat of the arbitration is in a different province. So that's pretty Lima-centric. That's a characteristic of our law that reflects, of course, most of our national uh, discourse on the centralization. It's an issue, and we have to work on it. But it's something that if you want to practice arbitration in Peru, you have to be aware about. So international procedures must seek judicial collaboration, like injunctive relief, enforcement, or annulment of arbitral awards. Uh, of arbitral awards through the Lima courts. Also, residual appointments, like the residual appointments or challenges, are addressed not by the local judge or the local courts, but by the local chamber of commerce. That's a very idiosyncratic um, It's a very idiosyncratic rule here in Peru. It's based on this idea and this lack of trust and lack of confidence on judicial decisions. Like at the heart of the discussion in when making this rule was this idea that judges in Peru are not very trusted, and mm, and uh, uh, and parties are usually very suspicious of judicial decisions. Therefore, uh, appointments or challenges are addressed, as I said, by local chamber of commerce or the institutions they create explicitly for that issue. I'm going to talk a little bit more about chamber of commerces in a little bit, but as I was saying, they are in charge of making the decisions regarding appointments or challenges when there is in a residual map, right? When there is no um, agreement by the parties. Curiously, the Arbitration Act has the 2008 Arbitration Act has been reformed only 3 times in its almost 20 years. First time to regulate the state participation. It was in 2015, so it's 7 years after the original issuing of the law. Um, After that, um, it was there was this modification to the law to the act um, to change the requirements for registration of interim measures due to anti-corruption legislation. So Peru and the U.S. entered into investment agreement, and this investment agreement had some requirements regarding anti-corruption, which led to legislation with to anti-corruption legislation, and therefore modify the requirements for the registration of interim measures. Um, it mm, it was not a particularly popular decision, but also not very written much about. There wasn't much written about it because it is sort of a niche issue, right? Arbitration, although it's very important in Peru, the registration of interim measures in arbitration is absolutely a niche issue. So, uh, although there were some commentary in, as I said, niche platforms, it wasn't really made a big deal of. But in 2020, the um, legislation, not legislation, I'm sorry, at the initiative of the executive, there was a new modification that established a 10% mandatory fee to interim measures issued in arbitration procedures where the state was a party. This means that whenever you enter into an arbitration procedure with a state, um, be it a municipality, regional government, or national government, even public-private associations, you would need to put down 10% of the total amount of the contract just to be able to get interim measures issued by the tribunal, the arbitral tribunal. This is a requirement that the state does not have to follow with because, of course, um, the state has this has privilege of not being required to well, not having these requirements for any interim measures, not in arbitration, but not in litigation either. So there is, in fact, quite different. And this decision actually did make a fuss. But it was 2020, COVID was all around us, and it was a little bit complicated to follow through with it. I know we have limited time, so I'm gonna push through a little some of the points that I was gonna make. Um, I was going to say that what I just told you is only the first part of the story, because the other and more important part is the fact that since the 90s, a lot of Peruvian legislation has tried to promote alternative dispute resolution. In 2009, we have the Mediation Act that makes it a requirement to start any commercial litigation in front of a judge, makes it a requirement to first go to mediation, and you need to have a uh, lack of agreement document signed by the mediator in order to be able to start litigation. So from 2009, it's mandatory to go first to mediation, and then we can proceed with litigation. And also, of course, since 1991, every public procurement act has referred every dispute related to public procurements contracts to arbitration. Most recently, they also included dispute boards as a means of dispute resolution. Thus, Peru has a great number of lawyers specialized and familiarized with mediation and arbitration through sheer necessity, because it is mandatory in both of these cases to be familiarized with mediation, arbitration, and now dispute board proceedings. Procurement related conflicts are so relevant to arbitration that almost 3 out of every 4 arbitrations in Peru are related to procurement contracts. I think the precise number is 72%. So 72% of arbitrations in Peru are arbitrations with the state. I mean, either against municipalities, regional governments, national governments, or private-public associations. Uh, so we have a big chunk of the arbitral practice here closely related with administrative law, procurement law, and therefore arbitrators need to pass a certification by the procurement authority here named OSCE, OSCE. Well, recently changed its name, which recently changed its name, and arbitral institutions as well. So, arbitral institutions to be able to manage procurement related arbitration need to pass evaluation by the procurement of authority, with the exception of the arbitral institutions sponsored by local chamber of commerce or universities. And there I have to reveal my bias that was mentioned at the beginning of the speech, where I myself, I'm a member of the council for the Lima Region Chamber of Commerce, and also I'm a registered arbitrator for the University of San Martin de Porres arbitral institution, Center for the Investigation, Research, and Solution of disputes, as it were. This gives a great deal of autonomy to Chamber of Commerce and university-based centers, and restricts the participation of privately and tailor-made institutions. As I mentioned, the Arbitration Act has a lot of Lima flavoring. Thus, the Lima Chamber of Commerce has greatly benefited from judicial decisions that refer arbitration to them, as opposed to other arbitration in arbitral institutions. In a manner very similar to what my dear colleague Jade Lauer, who talked several hours before me due to time zone difference, um, in a manner similar to the Coraline decision in Sweden. If you're not familiarized with it, it's a decision where the interpretation of an pathological arbitration clause was determined to be in favor of the Stockholm Chamber of Commerce arbitration center, um, due to the fact that it referred the arbitration to Sweden. It in a similar manner, when there is a lack of clarity regarding where in Peru we need an arbitration, sometimes the judicial branch has uh, defer to um, Lima Chamber of Commerce in the instances where it gets there, because as I mentioned before, the Chamber of Commerce is the one in charge of deciding uh, challenges, decisions, residual appointments, and even sometimes issues regarding competence. A final word regarding court rulings. We have very non-intrusive judiciary, but I'd like to talk about the Maria Julia precedent, which reversed expropriation made by the Ministry of Transportation uh, after the Ministry of Transportation failed to pay the compensation established by an arbitral tribunal that was called specifically to determine how much should be paid to this mining corporation, Maria Julia. So we don't, although we have a very non-intrusive arbitral trade, I'm sorry, although we have a very non-intrusive judiciary, they do take some decisions that are partial to arbitration and enshrine these decisions made there. So much so that the arbitral tribunals are allowed to decide on issues of reversing expropriation, which in Peru is an exclusively legislative power, national legislative power. So that, I think, paints a pretty clear image of the non-intervention of the judiciary. Uh, I, as I mentioned in the beginning, don't want to overtake the. I don't want to take over. I'm sorry. The time allotted to my fellow speakers. Once again, just want to say a couple words, because I was asked to, regarding the future of arbitration in Peru. I see a bright future for arbitration in Peru. I understand that we all see our field of practice as a promising one, but Peru in particular, and this procurement law that refers everything to arbitration, opens a big door for the practice of arbitration and the trial by fire, basically, of arbitration specialists. So I believe Peru is a particularly well-suited environment to sharpen your teeth in matters of arbitration and dispute resolution. I hope that makes us valuable assets when determining who you introduce or who you select to be part of your teams in matters regarding dispute resolution in um, international environments. So once again, don't want to overtake. Just one last word, if I may. I want to take advantage of the platform to remind everyone to keep in mind the horrible tragedy happening in Palestine. And of course, since we are in a Global South forum, just try to keep in mind the several struggles of many peoples for their liberation. So having said that, thank you so much once again for letting me partake in this event. And thank you so much to all the other speakers for sharing their knowledge. I myself just talked from, usually give this kind of speech from my lectern in class, and this is an amazing opportunity to share with the whole world. Thank you so very much.
Yeah. Thank you, Professor Miguel. We are very thankful from KFCRI. Within a short notice, you have accepted. Even the day next to your Sabbath, you are kind enough to reach us. And Ms. Samina, the part of KFCRI who couldn't join right now, or has a high regard to you. And obviously, we could see the presentation now, what happened, the message, what has been conveyed, particularly about the jurisdiction Peru in the Global South. Professor, we are going to have a long-term relationship with your university and your jurisdiction, particularly the tasks ahead, the GSADR Alliance. We need a long-term support so that all stakeholders in Global South have to be real players, making the traditional seat to be, whether it's Peru or whether it's Brazil, whether it's going to be India or any Global South country. Thank you, Professor.